My name is Chris Carlozzi. I'm the State Director for NFIB in Massachusetts and Rhode Island. NFIB is a non-profit, nonpartisan organization, is the nation's largest small business advocacy group as well. In Massachusetts and Rhode Island, NFIB represents several thousand small and independent business owners involved in all types of industries, including manufacturing, retail, wholesale, service, and agriculture. On behalf of those small and independent business employers in both Massachusetts and Rhode Island, I would like to present our concerns with increasing the overtime eligibility threshold for regulation. NFIB has consistently opposed changes to overtime eligibility thresholds. In 2016, when the Obama administration proposed increasing the thresholds from the current level of $23,660 to $47,476, NFIB felt that small businesses would be most impacted by the new federal regulation. Fortunately, in November of 2016, a federal district judge issued an injunction stopping the overtime rule. Then, of course, in September of 2017, a federal judge struck down the overtime rule, declaring the salary threshold that establishes which employees are either eligible or exempt from overtime was unreasonably high. In 2016, preliminary estimates produced by NFIB suggest the Obama-era overtime threshold of $47,476 would cost small businesses over 216 jobs, with an average per business payroll increase of $2,516 between 2019 and 2028. These estimates are based on projected cost to firms provided in the Regulatory Flexibility Act analysis of the Obama administration's final rule. In short, the proposed plan would lead to significant job loss and have a true fiscal impact on small firms. Once again, we feel any changes to the overtime thresholds would have a negative effect on small businesses across the nation. Main Street businesses throughout the country are experiencing record-level optimism because of beneficial policies coming out of Congress and the administration. This optimism and growth should not be placed in jeopardy with changes to the overtime rule. It would be a step backwards and a serious threat to small business confidence. Businesses would have to adapt if the thresholds are increased, and those changes will no doubt impact workers. Many business owners would be forced to transition salaried exempt employees to hourly non-exempt status rather than face the costs associated with providing additional overtime. Aside from serving as a perceived demotion, workers would lose certain job perks if moved to hourly employee positions. For example, many mid-level employees could lose their ability to work flexible schedules, use comp time, and in some cases no longer work from home. Among small business owners, the cost of even the threat of a lawsuit, including insurance premiums, legal defense, time away from the job, ranks second only to the cost of health insurance as a non-governmental impediment to business growth and opportunity. Litigation is a losing proposition for defendant small business owners, regardless of the eventual outcome, because of the inherent costs of litigation, including the cost of the defense, settlement or judgment, time or preparation, time away from the business, and the impact on employee relations. Small business owners are just one frivolous lawsuit away from closing their doors. It is unlikely that increasing the salary level will reduce litigation costs by reducing the number of employees whose exemption status is unclear. In fact, the very opposite of that scenario may occur by increasing the threshold, inviting more litigation to small businesses who are less likely to afford a drawn-out legal challenge. We would further urge the Department of Labor to consult with the Department of Justice to inquire if DOL has the authority to change the overtime threshold. NFIB submitted comments to the Department of Labor in September of 2017, questioning whether the department has statutory authority to impose a salary level test without Congress conferring such power by law. NFIB continues to stress any changes to the overtime threshold will have a negative impact on small business. Small Main Street businesses in Rhode Island and Massachusetts already face a myriad of new state labor costs. Rhode Island businesses are absorbing the cost of last year's new paid sick leave mandate, along with another scheduled increase in the minimum wage this January. Massachusetts businesses are facing a new assessment on workers that receive subsidized health insurance, the impact of a $15 minimum wage, along with the most generous paid family and medical leave mandate. Both states face extraordinarily high health insurance costs and a problem plaguing all of New England, highest in the nation energy costs. To add new small business cost pressures from the federal government would be ill-advised at a time where many employers have been optimistic regarding federal policy. Thank you for this time.